So welcome back, and I'll share with you the words we have of the section in the legislation. I thought it was up there. So okay, here is the relevant section we have. So if a mentally retarded woman becomes pregnant due to rape and she wants to carry on with the pregnancy, and the institution in which she is living wants to terminate, does this section permit them to do so? What do you think? We need to look at save as subsection 4 clause B, save as otherwise provided in clause A, no pregnancy shall be terminated except with the consent of the pregnant woman. So whether a mentally retarded child is included within this. I think I have not unmuted you people. Okay, now please respond. No, the voice is not coming through. Yes, please, anyone? Yes, please. What do you think? Whether consent of, and you know the distinction between mentally ill person with mental illness, and a person with mental retardation. Do we know the distinction between the two? Hello?
Ma'am, what was the question?
I'm asking the question whether this provision, what has to happen in case a woman with mental retardation with the mental age of 9 years has become pregnant because of rape in the institution in which she was living, in a state institution, state-run institution for women. So she became pregnant, and if she wanted to abort, then this section very categorically says, because of the mental trauma which she will suffer due to pregnancy being coming from explanation 1. It will presume to constitute grave mental injury to mental health, and therefore she can seek an abortion. But here is a woman who doesn't want an abortion, even though the pregnancy was due to rape. And she's in an institution. The institution people think that she's not capable of looking after the child. She's not capable of looking after herself. How can she look after the pregnancy and all? So the law, IPC says that you can abort only in these circumstances. Now, these circumstances, are they covering abortion, forced abortion on a mentally retarded woman who has become pregnant due to rape but wants to retain the pregnancy?
No, ma'am, they aren't.
Yeah, so what we should we do? What should be done in her case? What may be the possible arguments to say her pregnancy can be forcefully aborted, or arguments in support saying no, it cannot be aborted? Rahul, you were saying something?
Ma'am, may I asking a question?
Yes, please.
Ma'am, I
Who is
think
asking the question?
2014. Ma'am, Jiten Singh.
Your name?
Jiten Singh, ma'am.
हाँ जितेन पूछो.
Yeah, ma'am. I think exact time है
थोड़ा
2014 या
जोर से
16.
बोलो.
मैम यहाँ नेटवर्क इशू है.
हाँ हाँ, अब आ रही है
मैम
आवाज,
2000
बोलो.
मैम 2014 या 16 की बात है, कर्नाटका की.
हम्म.
कर्नाटक एक स्कूल गर्ल होती है, उसका रेप होता है
हम्म.
और उसे मतलब अबॉर्शन कराने के लिए मतलब सीएमओ ऑफिस प्लस मतलब डिस्ट्रिक्ट अथॉरिटी के थ्रू मिलता है, पर वो मैम 12 वीक से ज्यादा हो जाता है और आई थिंक शी इज नॉट
हाँ,
अटेंडिंग द
अभी
18 ईयर.
हमारे जो सिचुएशन है उसमें 20 वीक्स नहीं हुए हैं, तो 20 वीक्स तक तो दो के परमिशन से हो सकता है ना. तो
यस
लेट्स
मैम.
फोकस ऑन दिस वन. बस 12 वीक और 20 वीक्स के बाद में होगा तो सुप्रीम कोर्ट के केसेस और दूसरी कैटेगरी के हैं, वेयर इट इज नॉट अ क्वेश्चन ऑफ the woman wanting an abortion. This is a question where the woman want to retain the pregnancy. She doesn't want abortion. If she doesn't want abortion, can she be forced to undergo abortion? Because she is a mentally retarded girl, a woman who cannot look after even herself. That's the question. यहाँ 12 वीक्स और 20 वीक्स हुए हैं, तो 12 के बाद में तो उतना ज्यादा
Ma'am,
दिक्कत नहीं था पहले भी, बस 20 वीक्स तक दो
इज
मेडिकल प्रैक्टिशनर्स की
I think that she
कंसेंट
should
से
be
अबॉर्शन हो सकता था.
forced.
So in this case, yes, please.
I think that she shouldn't be forcefully made to like abort the child. Also, because if we abort the child without a consent, or it would be more traumatic for that particular girl. And also, if she's agreeing, though we agree that she's mentally retarded, but it would lead her to a greater. She would be in depression, or that there would be other following mental issues uh, if we forcefully abort the child of that girl. And I think she has the right to life, so I think she can decide for herself, though I agree she's mentally retarded. But if we forcefully abort the child, it would lead to uh, consequences which would be not fruitful.
Okay, for the purpose of consent, we believe consent has to be given by a major person. Her mental age is 9, her physical age is beyond 18. So whether consent is a mental function or is a physical function, arising from physical capacity or mental capacity.
I would like to go to a point here. I would disagree with what Astha said. There's Mental Health Care Act 2000, which has been passed on it, and it
Actually,
clearly defines about consent, who is able to take consent, and who is what is considered as legally ill consent. A person
Mhm.
who is by the psychologist, by the board of doctors, and it is certified and it's clarified medically and proved that she is not of an age to decide what is right or what is wrong, then the state or her guardian, if available, takes automatically the position of parenti patres, that is, of a parent, and would decide what is good for her. At a
Rahul,
mental age of
whether
9, she
whether
may
Mental
not
Health
be
Act,
matured enough
Rahul,
to.
I have a question whether Mental Health Act applies to persons with mental retardation or only with persons with
Ma'am,
mental illness.
it applies to the people who are with mental illness,
Yeah,
and
but you're
it
not talking about mentally ill persons, because mentally ill person may not be mentally ill all the time. The capacities may vary from time to time. But a mentally retarded child, a person, is with a mental age of a child of, in this case, particularly in this case, she was mental age of 9 years. So she is not a person with mental illness, but mental retardation, which say that her mental growth hasn't gone beyond the mental age of a 9-year-old child. So physically she is a major, but mentally she still is a child. So can we say that because she is a child,
it's challenging for her own life.
yeah,
So
I
here
lost
she has a right
connections.
to a life.
Yeah, so I was saying that she is not a person with mental illness. She is a person with mental retardation. So one possible argument saying that her consent is not
He
relevant.
might be. Yes.
No, hello, ma'am.
Yeah.
I would like to add like her consent will matter because
Yeah, we lost you. We lost your voice. Hello? Okay, I'm back again.
Ma'am, may I have a question.
Yeah.
Ma'am, if a person orphan lady, just like a refugee, if they are mentally retarded, or if they, the consent is required
That's
for
what the
the
question we're asking.
ma'am, if a lady or orphan lady, just like a beggar, ma'am, जो रेलवे स्टेशन से मिलते हैं,
And then
or
ये तो
refugee,
एक case है. This is the case which is exactly on this point. Let me share the screen. You see the screen?
Yes, ma'am.
Just 1 second. I'll have to. Okay. One more time. So Sujitra Srivastav is the case we're talking about. In this case, the woman was an orphan and she was living in the home for women. So she became pregnant. Yes. Okay. So in this case, the Punjab and Haryana High Court, she was in Chandigarh. So the Punjab and Haryana High Court permitted the institution to abort. And the Supreme Court has looked at the High Court decision. This is not behaving appropriately. The High Court asked for an expert opinion. And the expert opinion very categorically said, I'm sorry, this scrolling is not happening just now for whatever reasons. I do not know why. So look at the questions which were addressed by the expert committee. This is the section we are talking about, and it is in context that they have discussed. It's important to, so they said we need to talk about 2 questions in this case. And the 2 questions which the court looked at, first of all, look at the citation. So you can, I'll send you the citation in any case. This is a decision of 2009. Sujita Srivastava and another versus Chandigarh administration. And in this one, the Supreme Court considered 2 questions. One, whether it was correct on part of the High Court to direct termination of pregnancy without the consent of the woman in question. And the second one, they said, whether it was done in the, if the interest was, the second consideration before us is that even if the said woman was assumed to be mentally incapable of making an informed decision, what are the appropriate standards for a court to exercise in the parent's patria juris? That because she is incapable of looking after herself, she is herself with a child, and therefore the court should make the decision in the best interest of the child. So then they're asking the question whether, from that perspective, if the intent was to ascertain the best interest of the woman in question, it is our considered opinion that the direction for termination of pregnancy did not serve that objective. So they have taken this position that no, the High Court could not have done that. And they said the High Court did look at a number of considerations and ordered that before doing that, the High Court did set up an expert committee. The condition of the victim was declared as mild mental retardation. And board was set up before the High Court decision was, whether they approached the board, whether before the administration of the institution approached the High Court, they had recommended that the victim pregnancy should be terminated. But even then, the High Court even then appointed an expert committee to give an opinion on the matter, to judge the mental ability, mental status, affected ability for independent socio-occupational functioning and self-sustenance. She would need supervision and assistance. These are all the findings which I've highlighted, given by the expert committee. They also say she has adequate physical capacity to bear and raise a child. She is a case of mild to moderate mental retardation, which often limits the mental capacity to bear and raise a child in the absence of adequate social support and supervision. She has grossly limited perception about bringing up a child and the role of an ideal mother. She has limited understanding of the sexual act and relationship and even the concept of getting pregnant. She did not volunteer for sex and she did not like the sexual act. She has no particular emotional account of the pregnancy alleged to have been caused by way of rape, unwilling sex. She is happy with the idea that she has a baby inside her and look forward to seeing the same. This is the report on her mental and physical status. They said that we do not know much about her environment, etc. So therefore, we cannot make that recommendation. The possibility of complications like abortion, hypertension, premature low birth weight baby, and fetal distress are similar to any other pregnancy in the same age group. There was nothing specific about this woman. Her physical status poses no major physical contraindications to continue with the pregnancy. Mental state indicates limited mental capacity, intellectual, social, adaptive, and emotional capacity to bear and raise the child. And on this basis, the committee did recommend abortion. Expert body, even though the expert body's finding when, okay, no, they did not favor continuation. They favored the pregnancy, but the High Court directed the otherwise. We disagree with these conclusions in the victim has clearly expressed her willingness to bear a child. The applicable statute clearly contemplates that even a woman who is found to be mentally retarded should give her consent for the termination of pregnancy. There's no specific provision, but there's no exclusion of any categories of women. Therefore, the court has taken this position. So in this case, the court did grant continuation of pregnancy. So our question is that whether, and therefore said, because they were volunteers, there were NGOs which said we will provide her the necessary social support, social psychological support in bringing up the child. And the court says, yes, yes, it is the right of the child. Let me see if I can find that para again. So the judgment was given not only on the basis of this clause which says her consent, but also that she will be very unhappy. So from the best interest principle, the judge said that she will be very unhappy, and therefore we do not say that this was done in her in the best interest of the woman concerned herself. Where is this section? Yeah. So they said there is a compelling state interest in protecting the life of the prospective child. And because the prospective child has a right to be born, and therefore the state could claim that it is the guardian of the pregnant victim since she is an orphan and has been placed in government-run welfare institution. However, the state's claim to guardianship cannot be mechanically extended in order to make decisions about the termination of a pregnancy. An ossification test has revealed that the physical age of the victim is around 19 to 20 years. This conclusively shows that she is not a minor. Furthermore, her condition has been described as that of mild mental retardation, which is clearly different from the condition of a mentally retarded person, a mentally ill person, as under the Mental Health Act. And therefore, so determination will not be in the best interest of the victim. So the question which has remained, that whether this case lays down a general law saying that in all cases where mental retardation takes place, whether pregnancy has happened to a person with mental retardation, in all such cases, they must be allowed to continue with the pregnancy. And if so, then what happened? If suppose there's no volunteer coming, she still wants to continue with the pregnancy. So will the court in those cases also say now the state will have to provide that necessary support? If they say so, that in all cases where mentally retarded persons or persons with mental illness not capable of taking continuous care of the children will have to be provided with child care support, then it's much more focused on the woman's right to have children through their body. But otherwise, it's just it's a one-stop arrangement. That, okay, this woman came, these NGOs came, they said we'll support, and therefore we'll grant. So coming back to the section we had, very categorically, the section is clear that the pregnancy can be terminated only when these conditions exist. And it is limited in its phase to, is it granting any reproductive rights in the sense of deciding when and how to have pregnancy, when and how to terminate pregnancy?
Ma'am, I would like to give my points on this for 2 minutes.
Yeah.
I read this case and I found only few points on it where the High Court, it ordered two medical boards, and Punjab and Haryana High Court gave two medical boards, while the first board recommended for termination on the grounds of substantial risk to the physical and mental health of the woman, pregnant woman, and it also gave advice that there is a strong possibility of serious physical or mental abnormalities as it can result in a serious handicap of the child. But similarly, the second board that gave a very more nuanced verdict. It noted that there are several health problems. For example, her positivity of Hep B, hepatitis B, because her surface antigen were hepatitis B. But still, it did not rule. The second board did not rule in favor of termination of a pregnancy, because it finally gave that physical status Toto doesn't pose any contradiction to continue the pregnancy. But even though the High Court directed the terminance of pregnancy in for her best interest, even of with this two different medical board. But what I want to focus is the Supreme Court stayed the order of High Court primarily. There was one reason, that was the terminancy of pregnancy at that stage where the case was in Supreme Court, that was 19 weeks. That was not in the interest of the petitioner, that means the woman. And if the pregnancy was terminated, then it would be directly causing a life threaten. It would threaten her life. Therefore, it went into the dimension of Article 21 and said, okay, this can endanger her life, so we will not go ahead with the termination of pregnancy. We would let her continue. But then after all this happened, there was an amendment, Act 64 of 2002, which said that mental retardation may be incurable, but person always has a fundamental right and they can be a part of social mainstream. So all mentally retarded women who are above the years of age of 18, like major, they will always have the right to self-determination. So the act has always been passed. So now if there is a woman
No,
who
Rahul,
is
in this
major,
case, her mental age was 9 years. Mental age is not above 18. The judges are only looking at the physical age. So the question
Even
I
at the
was putting
physical age,
forward
ma'am,
is,
yes, even in the physical age, that Supreme Court only went towards, okay, if we terminate this pregnancy, it will be life-threatening. So she has a right to live. So let her continue the pregnancy.
no, because
No, ma'am, I would like to
the
add that
judgment
even
has
if we
come
look at the
later.
definition,
The judgment has come later, but the stay on the High Court was the High Court order was set aside, and she was the court has heard and held an urgent hearing when she was 19 weeks pregnant, and that was the ground for an urgent hearing. And they decided that no, we're not going to order termination. Therefore, the order came later. But that was not the reason. 19 weeks, they were not talking about at all that it will be against her health. That was not the reason. They looked at the expert committee which the High Court had constituted in addition to the boards. There was a medical board and there was an expert body. And I'm reading para 31. The findings recorded by the expert body which had examined the victim indicate that the continuation of pregnancy does not pose any grave risk to the physical or mental health of the victim. And there is no indication that the prospective child is likely to suffer from a congenital disorder. However, concerns have been expressed about the victim's mental capacity to cope with the demands of her carrying the pregnancy to its full term, the act of delivering a child, and subsequent child care. In this regard, we direct that the best medical facilities be made available so as to ensure proper care and supervision during the period of pregnancy, as well as for postnatal care. Since there is an apprehension that the woman in question may find it difficult to cope with maternal responsibilities, the chairperson of the National Trust for Welfare of Persons with Autism, Cerebral Palsy, Mental Retardation, and Multiple Disabilities Act has stated in an affidavit that the said trust is prepared to look after the interests of the woman in question, which will include assistance with child care. In the said affidavit, it has been stated that this trust will consult the Chandigarh administration as well as experts from the Postgraduate Institute of Medical Education and Research in order to ensure proper care and supervision. If any grievance arise with respect to the same subject matter in the future, the respondent can seek direction from the High Court and Haryana under the jurisdiction. There's no reference to the health of the child being in question at all. None of that has been recorded in the judgment. Very categorically, the judge said in this case that because the expert body has found, referring to section 3 of the MTPA Act, that there's no danger of any physical or mental health being affected, and therefore no question of pregnancy being terminated. And in addition, there is this National Trust people who are ready to support her, and therefore we will not grant it. So what we're coming back to is that when it comes to the question of consent, the unaddressed question has been that in determining consent, are we going to look at consent of the mental age of the persons? And this is not limited only to pregnancy termination. It will be true for all other cases. For example, if this is this girl has whether in her case it's rape or not. She didn't like it, she didn't ask for it, but did she consent or not? She doesn't have a concept of consent when it came to the rape category. But we are accepting her consent when it comes to pregnancy. We say her consent is not there because she did not ask for it, and there's a very vagueness about whether it was a consensual act, it was a non-consensual act, but she didn't like it is what has been recorded there. So for purposes of rape, what age we will be looking at her? Whether her mental age or whether her physical age. For purposes of pregnancy, we are looking at her physical age, physical capacity. But if the question of abortion in case of children is decided by the parent or guardian, whether the same principle will apply in her case also or not. That's my question I would want us to think about. Yeah, so what do you think?
Ma'am, it's a very, very difficult question.
Yeah, no, I'm just, as lawyers, we do not have to agree on everything.
Ma'am, in a
what
case,
we're saying is the
in a case where
possibility of
pregnancy
arguing,
is
because in this
related,
one, the question of mental age and capacity to give consent has not been dealt with. So an aspect which has not been raised, the judge will not deal with that. But as academic, as students learning the law, we can ask that question. That when determining that whether there is consent or not, this section is very categorical when it comes to children below the age of 18. It says in their cases, the pregnancy can be terminated only with the permission of the guardians, consent and writing of a guardian. In this case, her guardians are the state institution. So if the guardian is there and her mental age is less than 18, so the word not attain the age of 18 years be seen only in terms of physical age, or whether mental age should also be part of that conversation is what I'm thinking. I'm asking you, all of us, to think about as lawyers, that in future, whenever there is a question of consent, whether we will be looking at, certainly when there is no mental retardation, when there's no mental illness, we are only looking at the physical age. But when there is a specific case of mental retardation, which means that the mental capacity of the child hasn't improved, hasn't developed beyond a certain age, and age of a child. If it is at the age of 18, then it's fine. But if it is anything less than 18, then mentally she is still a child. So whether her consent should be of paramount importance. And in this case, the judges said that her mental health will be affected if she, if it is forced abortion, then she will be unhappy, and therefore it is not in her best interest. So far so good, if we can agree to that also. But the moment the consequence of this recognition that going through this pregnancy will make her happy to have a child, is only looking at this child, we're not looking at the child which will be born out of this. So what about the child who will be born out of this one? In this particular case, it is just and fair because there is an NGO which has come forward to look after the child mother as well as the child who will be born from this pregnancy. But that does not solve the problem of generically the issue of consent.
Also, if you look at the
I
definition of mental retardation, it says that there's significantly sub-average intellectual functioning. So it doesn't mean that every child was mentally retarded, and the degree of retardation, so to say, it is not same, or like it's not it's not same with everybody. And also there are particular limitations regarding the retardation. For example, some are not able to communicate, or some are not able to give self-direction, or etc etc. So we cannot just say that we have to look at the degree of mental retardation in particular case for deciding.
So certainly what we're saying that we needed a more nuanced analysis of the situation when it came to consent from a mentally retarded woman in case of pregnancy. Because this issue is not limited only to the woman who is consenting or who is wanting a child. It's also a question of the other child which will be born from here. So all those nuances, the discussion is not found. But certainly what we have learned from this case is that you cannot say just because this person is not fully developed mentally, therefore we will decide for. It's not a simple yes and no answer. It has to be a nuanced analysis of the circumstances, and a case-by-case decision-making will be required. It has been done in this case. We cannot take it that in all cases will be permitted, in all cases it will not be permitted. I think the expert opinion and analysis of the expert opinion will become an important tool in determining what is the best decision in such a case. So the decision to abort is easier as per within the guidelines of the law, but decision to retain the pregnancy is a harder one in cases like this, which are not covered directly, but have a lot of other concerns in the safety and future of the woman concerned herself, and as well as the future of the child concerned. So again, we are running out of time. We'll go into the third meeting.